there are a handful of other anti-discrimination laws, and this one in particular is called the Genetic Information Non-Discrimination Act, or GINA. This was passed in 2008, and basically it prohibits people from discriminating based on genetic information. So if you've got genetic makeup, and let's say you are more likely to have cancer or more likely to have mental illness, a company can't refuse to hire you. They can't refuse to insure you. Health information needs to be kept separate from employment decisions. That's really the bottom line of the whole thing. No one is allowed to know your family medical history. It's none of their business when it comes to hiring. I referenced earlier about the Equal Pay Act, and I said that it had been amended, and it was amended in 2009. This was actually one of the first pieces of legislation that Barack Obama passed into law, or had passed into law, which was an amendment to the Title VII and the ADEA and the ADA. Basically, Lilly Ledbetter found out that she had been a victim of pay discrimination, but by the time she brought her charges, they said it was too late, that the statute of limitations, for whatever reason, had passed. But the problem is, that if you remember, I said earlier, when companies say you're not allowed to talk about pay, it's really difficult to figure out whether or not you are being paid fairly. So they changed the law, so now you are allowed 180 days from the time you find out about the discrimination to make your claim. So basically, if you take 180 divided by 30, you've got 6 months from which to file a claim. So even if I was discriminated against 15 years ago, I'm still with the same company. Once I find out, I only have 6 months from that point in time to be able to file a claim. In 2020, there was the Bostock decisions from the Supreme Court that said gender identity and sexual orientation are considered part of Title VII. Now, the EEOC had provided guidance on this a long time ago, but the courts did not support it at that time. And finally, it took a few lawsuits. It went to the Supreme Court, and in 2020, they did find that LGBTQ plus workers were considered part of Title VII and could claim a form of sex discrimination based on gender identity and sexual orientation. Now, some of that's been narrowed a bit, and of course, the current administration is pushing back on this. But right now, it absolutely is protected under the law. Nothing has changed legally. What has changed is how the President of the United States is making a decision about how to handle that. And he's trying to use executive orders rather than the legislative process to make those changes, which is not going to stand up for long. Lastly, there are a number of laws that protect our vets. For example, the Vietnam-era Veterans Readjustment Assistance Act prohibits discrimination against applicants based on their status as Vietnam vets, and in fact, it encourages us to find ways to hire them. It does prohibit harassment and provides for reasonable accommodations for people who are vets, particularly during the Vietnam era. Then the Uniform Service Employment and Reemployment Act, USERRA, guarantees active duty personnel, military personnel, the right to be reemployed after they come back from the war. And this it also works in alignment with the Family and Medical Leave Act. When someone's gone for a certain period of time, they also have the right to get their job back. But it's reinforced with USERRA. So both of those laws at the same time really work to make sure that our vets are protected and that they are not discriminated against because of the need to serve our country.